Good afternoon, everybody, and you're very welcome to this, the third webinar in the Victims' Rights Alliance series of seminars about issues that impact victims of crime. Today, our subject is the O'Malley Review, Progress and Challenges. The O'Malley Review of the Trial of Sexual Offences was published in August 2020. So a year on, we want to explore today its implications and perhaps the differences it is making and will continue to make to victims of sexual violence who engage with the criminal justice system. The then Minister for Justice, Helen McEntee, immediately accepted the recommendations of the review, and there have been several committees working on implementation plans and progress. So it will be really interesting to see how far we've got and indeed how far we still have to go. I'm Eve Lewis, I'm the CEO of 1&4 and I'm chair of the Victims' Rights Alliance. So I'm delighted to introduce today two speakers. The first is Miriam Delahunt. Miriam is a barrister, a practicing barrister. Miriam also holds a PhD from Trinity College, and her great area of interest is children and vulnerable witnesses in the criminal justice system. She has a forthcoming book coming out, a practitioner's handbook looking at vulnerable witnesses and defendants in the criminal justice system. Our second speaker is Nolene Blackwell. Nolene is a lawyer by profession and has been CEO of the Dublin Rape Crisis Centre since 2016. In her work in the Dublin Rape Crisis Centre, Nolene has first-hand experience of the challenges that face victims of sexual crime as they engage with the criminal justice system. Each speaker will speak for 15 to 20 minutes, and then there will be time at the end for questions and comments. And you can use the Q&A function on your screens to send us questions, which will be addressed at the end. So I'm going to, without any further ado, ask Miriam to begin her presentation. Thank you.
Thanks very much, Maeve. It's very much a huge honour to be here today discussing these areas which are rapidly changing. As Maeve said, I have been fortunate enough to be studying this area in Trinity actually since 2009, when I did a dissertation on intermediaries for my master's, and then that led to doing a PhD on support measures for child witnesses in criminal proceedings. After that, getting the PhD, there's always kind of like, are you going to do the book? And I've been trying to work on the book. Apart from my own procrastination talents, there has been a consistent period of change. We're waiting for the Victims of Crime Act, waiting for preliminary hearings. And so while my book will be as practical as possible, it really is interesting that it's looking at has been looking at an area of change that is continually changing for practitioners, for not only for vulnerable witnesses, for vulnerable victims, and for defendants as well, because that's also an area that is more light, I think, is being shed on the difficulties for defendants that could also avail of a better understanding. But looking at for vulnerable victims and witnesses, certainly the Victims of Crime Act, since that has come in, has changed things radically. So just to set out my stall, while things are changing greatly, I would say that obviously the court system is really not the area for anybody who is coming in with the kind of trauma or difficulties that would be represented through sexual offences, and the O'Malley report certainly highlighted a number of issues that would be really do need addressing. And I'll just be looking at a couple of those really, because the O'Malley report is quite extensive, and I don't think anybody would have disagreed with anything that was in the O'Malley report. Certainly from a practitioner's point of view, I think that there is a huge willingness to change in a system that really doesn't lend itself to change. It is an adversarial system in which one person says something and another person says that didn't happen like that. And so by its nature, the adversarial system is going to possibly cause more trauma, more secondary victimization, as was put in the EU Victims Directive, and then also has been seen in the Victims of Crime Act. and that unfortunately is still the case. However, what has improved, I think, over the last few years is a greater willingness to accept that our system is very flawed, how we can address some of the issues. And looking at that, I think the O'Malley report certainly highlighted delay and preliminary hearings and the issue of disclosure as issues that really are so problematic within any trial system, any court system. Looking at preliminary hearings, there was a general heads of scheme bill around for ages since 2015. And finally, we do have the Criminal Procedure Act of 2021, which has not been commenced as yet. And the section itself, section 6, is pretty uncontroversial in terms of what the trial judge can do prior to a trial commencing. And I think the aim of it is really, I don't think it's not very complex. What the aim is to have some kind of sense of certainty as to what is going to occur prior to a trial, before the trial occurs, but before the jury is in charge, before everything starts on the trial day. Why we haven't had those before is because we have had general practice directions which have had no teeth, because really nothing can happen until the trial judge starts the trial. And so then with the preliminary hearing, that is really to try and get that in hand, and that the trial judge or somebody else who makes an order as to what's going to happen it will actually have strength when it comes to the trial. The difficulties I do see is that, first of all, it hasn't been commenced because we're still waiting for the rules of the court to be amended. And I think that Nolan probably can speak to that a little bit better than I can, but I think there's difficulties, and it's complex, not difficulties, not insurmountable, but that it does take some time, but that it does seem to be on its way. However, in limited circumstances, the section 5 of the Act says that it's really only for sentences that are 10 years or life imprisonment, and so that's a little bit of a limitation, although there is provision that the minister can make orders that would change that, would expand it. So it's just disappointing that we're still waiting for that, but it is on the way, and it certainly is, it has been signed into law. It hasn't been commenced as yet. And how that will act, I think, remains to be seen in the courts, whether or not it's actually going to really change things, because the biggest thing that is the difficulty is disclosure. And you can see Court of Appeal judgments like DPP and SA, where there was 7 years in between the reporting of the offences, the recording of the offence because there were child victims, the recording of their testimony, and then 7 years in between them being 10 and 12 and them being 17 and 19 when it came to trial. And one of the reasons why it took so long was because of disclosure. One trial date fell because of disclosure. Another trial date fell because of lack of judges. So we're still dealing with difficulty with disclosure. And a trial a couple of weeks ago in relation that I was involved in, only the weekend before the trial was supposed to start, there was the Friday before, there was a late disclosure from the HSE. Unfortunately, that meant that had to be gone through. Then there was ramifications around the effect of that. And unfortunately, then that has meant that trial didn't get on. So that is a consistent recurring problem. And I think that any preliminary hearing legislation will try and deal with that, and also deal with anything pre-trial, such as support measures that might be available for that particular witness. But it remains to be seen if the current memos of understanding between HSE and all the interagency working can actually get that to a state where that is no longer a problem. Because if you don't have full disclosure, you are undermining the rights potentially of the defendant. They can't get a fair trial. Therefore, it is one of those things that just has to be done. And it's no surprise to, in this day and age with extensive mobile phone data, extensive computer data that has to be gone through, that's going to take more time, and it's a resource issue as well. Therefore, it's very difficult for the Gardaí and then barristers to get that done as soon as possible before a trial, and therefore the trial date might be lost, then it has to go back, and then we're dealing with delay. So in terms of disclosure and delay, we need more judges. That has been in the papers recently. That we certainly have had new appointees, which is fantastic. But whether or not it's actually going to deal with the delay due to COVID, and then also the delay that was in the system anyway, that is unfortunately, that's another aspect of the O'Malley report that was highlighted and has been highlighted in the follow-up Supporting a Victim's Journey report of Helen McEntee, which is fantastic that these are continually being highlighted, but how they're being addressed, it still means that at the end of the day, if trials don't get on, a victim, a complainant, is left wondering and in a state of uncertainty, and that's still all too prevalent at the moment. However, you know, things I would just also mention in terms of disclosure, going back to the O'Malley report and Section 19A, which is brought into the Criminal Evidence Act about counselling notes and disclosure of counselling notes. I think it was really there to try and give some agency and some control to complainants who might be able to then say, no, I don't consent. But I think that can also cause difficulties for trials if then there is a third party who's looking at the notes saying they are relevant, and then there is still no consent as to whether or not they're going to be looked at by the court. I just wonder the circumstances around it, how it's actually working for people in practice. The O'Malley report says that it's not as known as it could be, and that it's not as used as it could be. I'd be really interested to see what you think about that, and what Nolene thinks about it, and Maeve thinks about that, as to its efficacy, or is it just window dressing? I don't think it is window dressing in terms of that it is very functional, it is very detailed as to the agency it's trying to give to people who have counselling notes, but who may not wish to consent about that. But I wonder to what extent are there any other solutions that we could have around that. I think that there is still difficulties in relation to the Victims of Crime Act as to the Section 15 assessment. That might be a Garda resource issue as to the knowledge of what support measures are available, what can be done, because there's stuff coming into practitioners are looking at things saying, well, I don't know if actually an intermediary is available for that particular complaint because they're not eligible. And so that brings me to another point, which I would say is that in relation to the legislation that was changed by the Victims of Crime Act, which it wasn't really mentioned in the O'Malley report, but we're still moving towards the Victims of Crime Act being very, very useful and relevant, and making sure that there is a greater understanding of the needs from first reports to sentencing of victims. I think that's fantastic. The act itself is great, but one area I would have problems with as it relates to practitioners is how it amends the Criminal Evidence Act, because even though it really does do a huge amount of amending for victims, it causes a huge amount of complexity as to the eligibility for persons who are coming within a relevant offence or not, or a victim of an offence other than a relevant offence, their age, as I say, the crime that's involved, if they're a witness to it or a victim to it. And I think it kind of speaks to the fact that, are we looking, is it because of a resource issue that we're not looking at making that kind of change to our legislation for persons who are coming to the courts saying, I have been hurt in this way, and the quality of my evidence will be diminished if I don't get support measures that can facilitate me telling you how I was hurt. So that's the quality of the evidence, first of all, and also then the possible and potential risk of hurting people who are then in the courts themselves. So we're looking at, as they say, secondary victimization, traumatization has entered into the language of the Criminal Evidence Act. But because it's still so complicated for practitioners to get round as to what exactly somebody might be eligible for or not eligible, that it makes it very difficult to say, well, actually the Act itself is really, if you're only in this particular area, then you will be eligible for this, or if you're only this, then you'll be eligible. We shouldn't be really looking at how people can be assisted. Anybody can be assisted to say to the court, well, look, my evidence will be better if I can get an intermediary, because they'll be able to help me explain better. And also, so the quality of the evidence will be better, and also I will feel better protected from the adversarial process. And so that opening up, as I've heard people in 104 talk about an emotional understanding of the people who are coming before the courts, I think we're not getting there yet. We are getting to a point where we can try and understand better. And I will say that practitioners are very, very hungry to understand this legislation, how they can better assist, but they really are hamstrung by an awful lot of the things that cannot change in terms of court lists and delay, disclosure, and also the workings of the adversarial system, as I say. But at least there is, you know, the Bar Council will be running CPDs in a couple of weeks' time in terms of vulnerable witnesses, the use of intermediaries. And even though intermediaries are really for only under 18 or for persons with a mental disorder under the Act, even the DPP is putting them into the court process. We've seen, I think in the Munster trial, which I was observing, I think that how they are educating practitioners and judges as to the language with which that practitioners use, which even unconsciously may elicit unreliable evidence. And I think that's where you're looking at that what the court system is there to do, is to try and have reliable evidence before the court so that the jury can decide the facts of the case. And so also woven within that is a explaining what is going on, asking questions that can be understood, and making sure that there is a better discourse within the courts. And I think that's really important. Unfortunately, as I say, you know, there's 2 Northern Ireland intermediaries who are working within the court system at the moment. Our legislation is very limited within supporting a victim's journey, and intermediaries, I think also in the O'Malley report, very, very really positive element within the court system. But supporting a victim's journey is talking about getting tenders for training and then panels for intermediaries that the courts can draw on. That's still in the future, but seems to be, the Department of Justice report is saying that all of those, that checklist of yes, we're on our way to getting those done, that seems to be achievable. It'll take some time before that comes through. So things are moving in a better direction with the Department of Justice, also looking at requests for tenders for streamlining the system, looking at how sexual offences are being processed. Again, in the future, that data has to come through. And I think honestly, we need more data. I think we need to know exactly what the experiences are on a continual basis, on a consistent basis, as to things that are working and not working, so that there will be consistency across the board. I think I am certainly, unfortunately, very Dublin-centred, where I'm speaking to you from the Criminal Courts of Justice, where there is a witness suite, there's video link facilities, there's a shared knowledge of practitioners on the 6th and 7th floor who can ask each other what's going on. It might not be the same across in terms of the facilities, in terms of the knowledge base, the ease of understanding of what's going on, how somebody did something in a particular court that could be then transferred to another court. Because it's that so many of these trials are in camera, that information doesn't get out as easily as it as it might do in other cases. And so I think we need better. I know the O'Malley report was fantastic in that way of highlighting these issues, so as supporting the victim's journey. And that's where I think an awful lot of the progress will be, to have these issues highlighted so that there will be not only developments, but a consistency and a better level of awareness of those problems. I will leave it there. Thank you very much indeed, and I'll be happy to ask any. Nolene is going to take up, and I hope, on many of the issues that I've asked, and I'll be happy to answer any questions that I can.
Thank you so much, Miriam, and lots of food for thought there. I mean, in some ways, quite an optimistic view of what could change, but at the same time, the huge challenges that remain. So I'm sure there'll be lots of questions. Can I now introduce Nolene, who will be speaking from her experience in the Dublin Rape Crisis Centre. So Nolene, we'll hand over to you.
Thanks very much indeed. And Maeve, thank you for inviting me to be part of this seminar. It is both a privilege and a pleasure to be part of it and to be talking to colleagues. And indeed, I think I could nearly have just not prepared anything for this, because Miriam's talk was so interesting there that I could just kind of bounce back on her. So look, we might have a chance to do that a little bit along the way. But meanwhile, I'm just going to run through maybe some of the other areas that we are noticing in relation to the O'Malley review and the subsequent implementation plan, sharing the victim's journey. And I'm going to do that thing of trying to share my screen now and hope that it works. And there we are. So I think that is coming up okay for everybody now. I certainly hope it is. I will move to slideshow and from the beginning, and just what we're speaking about is progress and challenges. And I think Miriam has spoken already about, you know, things being stacked up and put in place, but not there yet. And that is true. But we definitely, I mean, we're dealing with a justice system that has not addressed the special issues that arise in sexual offence cases. If ever they address them, it certainly hasn't been in recent years. So just in what I'm going to talk about, I'm recognising that the O'Malley review itself and the implementation plan is considered by the state, by the Department of Justice, as a living document. And in addition to looking at that, we also have to look further beyond it to the audit of domestic, sexual and gender-based violence structures that was completed in June of this year and is on the Department of Justice website, done by my predecessor in the Dublin Rape Crisis Centre, Ellen O'Malley Dunlop and Mary Higgins, and the fact that as we speak, the government is developing a third national strategy on domestic, sexual and gender-based violence. And my apologies for shortening it there. I try not to do that, but just some acronyms get in on you after a while. So what I understand at the moment from an update that was given to the monitoring committee of the current strategy, which is due to expire at the end of the year. We believe that the third strategy is going to have a draft for publication this month or next month. There will be some public consultation on that, and then it will be finalised thereafter. So that there is, because O'Malley on its own can't do all of the work that's needed for victims of sexual violence who are in the justice system or in other systems. So there needs to be a much wider strategy. And in addition to what the O'Malley report sets out there has been a review of victim support services, which have grown up organically, which is a nice way of kind of saying sometimes topsy-turvy, but certainly all have grown up without sufficient funding and without sufficient recognition, and therefore have lacked that sense of consistency that's so necessary. A piece of work has gone on mapping the journey of the victim, and there will be further initiatives. And one of those issues that's being raised in mapping the journey of the victim and is being taken forward as a further initiative is the real challenge for those who are in the justice system, who may actually be dealing with 3 different jurisdictions at the same time. So they may very well be, in the first place, a victim of a crime and therefore a witness in a criminal trial. At the same time, if the offences are committed by a partner or ex-partner or a family member, they may be in the family law courts with a whole different set of standards and a whole lot of different issues to be dealt with as well. And they may indeed also be in the child care courts at the same time with child protection issues. So those 3 jurisdictions, that the one person with all the problems that are associated with being a victim of crime, with being a person who is left at the end of a broken relationship, and with being involved in the child protection system, none of those, well, they rarely joined up, and certainly it is clear that for the most part, the officers in those 3 jurisdictions all think their job is the most important. And that can be very frustrating and very difficult for people. The O'Malley report, and I'm not going to dwell on this, but the O'Malley report did make it clear that we weren't starting from nowhere, that even before it came in, there were some existing protections for victims, and that some work was being done. And that, of course, is true. Since 2016, 2017, there has been a suite of legislation which has come in, and the Sexual Offences Act of 2017, the Domestic Violence Act of 2018, the Sex Offenders Bill has fallen and risen several times within that. And the one that is well known to people in this Victims' Rights Alliance, the Victims of Crime Act, all form a wider framework for victims of crime. And O'Malley recognised that as well. And O'Malley then goes on, and Miriam spoke about vulnerable witnesses. And I think from my money, this is something really important, where in the report says vulnerable witnesses doesn't have a settled meaning. It would seem, first of all, to refer to people who are vulnerable by virtue of a personal characteristic, such as youth or mental or physical disability. And in our current system, they're the ones who are seen as vulnerable in terms of special protection measures. So undoubtedly, they are vulnerable witnesses. However, it appears to the review group that the category should not be so confined, as there is a widespread view, and in the group's opinion, a defensible one. Tom O'Malley's always very cautious in his language, but he says that witnesses in criminal trials, particularly sexual offence trials, may be vulnerable by virtue of the circumstances in which they find themselves, even if they are not inherently vulnerable by virtue of age or disability. And certainly that would be something that we in the Dublin Rape Crisis Centre and colleagues in rape crisis centres and 1 in 4 and other places would know that as well, that vulnerability can be just a matter of your circumstances rather than something inherent in yourself. But what I noticed that while he says that, there is no recommendation, and I don't know of any moves afoot to actually encapsulate that in a way that requires the officers in the justice system, be that prosecution, defence, or the judiciary, to recognise that level of vulnerability. And so while that is there, it is also true that this report has its limitations. And I would say one of the limitations is that the place of the victim is still on the sidelines. The place of the the victim complainant is still on the sidelines, because, to quote from the report, the criminal trial is essentially a binary contest, and even the use of the word contest is interesting, between the prosecution and the defence. The procedural and evidential rules which have evolved over time are based on that assumption, and later in the same paragraph, this doesn't prevent every reasonable consideration being accorded to witnesses and victims in particular who testify. But in spite of the reality that in this type of case, the evidence given by the victim complainant, as we all know, is more crucial than in so many other cases, and that it turns out so often to be a swearing match in some ways between the defendant and the victim as to whose account is the most credible for a jury in terms of identifying, did consensual sexual activity take place, or was it non-consensual, giving rise to the assault or including the rape. But in spite of that, the settled view of the report, and I would say much more widely in the legal system, is that the introduction of separate legal representation for one category of witness throughout the entire trial would risk upsetting that well-established balance. There are recommendations for small adjustments to the level at which representation is provided. They are recommended, but it is not recognised that in these cases, the victim complainant is very often the only person in the court who is there entirely without preparation and without representation in something where their account is crucial to whether or not somebody is acquitted or convicted. Anyway, I'm going over old ground there, that's well known here. So again, and again, probably just going back over ground you all know, there were 4 overarching recommendations in the O'Malley report, even beyond the trial process. And I think, again, we would say, I would say from our experience, that's really important to promote better awareness of victims' rights legislation. And even as Miriam was talking about the complexity of, you know, what supports might be available to somebody, it strikes me that that's an area where there does need to be better awareness of the victims' rights legislation and what it means, promoting education around consent, interagency awareness and cooperation, and there's a lot of thought, as I understand it, being given to that at the moment, and consistency in service delivery, and that was part of the mapping of the journey. So in terms of increasing public awareness of the Criminal Justice Victims of Crime Act, there is to be increased visibility and awareness of the Victims' Charter and comprehensive public information, and probably now, as Miriam was talking, I thought maybe more legal information as well, including this website. So that is being built up. Public education on consent is to be advanced, and there is part of the Department of Justice already committed to that, and we're talking to them in Dublin, in the Dublin Rape Crisis Centre, as we develop our own, I suppose, area of priority in relation to a consistent message on consent, but they recommend website, school programs, programs for disability service users, as what's called, programs for parents, and awareness raising. Interagency work is the audit, the mapping, the next national strategy, and training needs across a range of victim supports. And finally, facilities for victims should be consistent. And again, Miriam touched on that, the fact that, you know, it's one thing to be sitting in the CCJ, and it's a whole different thing to find yourself in a country court, or you know, another city court, or even a court in a different part of the same city. Garda interview suites also to be advanced. So there are then a set of other recommendations that come up, and I am going to look at the ones that are highlighted a little bit there in terms of investigation, trial, information. I go back to delay a bit, even though Miriam has spoken on it, and training. So in terms of investigation and prosecution, specialist training for frontline Gardaí and experts monitoring specialist Garda training. Our understanding is that there is a lot of pressure now on Garda resources in this area, that a lot of people want to report, and that we are going to see a significant difficulty there. It is really, really important in our view that those who are conducting investigations into sexual offences maintain or have and maintain standards of investigation consistent with their knowledge of how sexual offences differ from other types of investigation, and need that specialist approach. As a result of that, Division and Protective Service units need to be fully resourced and fully staffed, and to have the right resources in terms of interview suites, etc. I understand that the Office of the DPP in Dublin does have a sexual offences unit in place now and is rolling it out regionally. So then in terms of the trial of sexual offences, again, without going to the delay one, which I'll come to later, there is a limited extension of legal representation, which is currently so minimal and so poorly organised in terms of how much time the Legal Aid Board get to supply it, where they find the barristers at short notice who can do it. It's really poor, and I think that was recognised. But there's to be a limited extension so that it is extended, first of all, to all sexual offences, which it currently is not, and that insofar as there was representation previously on the application to admit evidence of sexual experience, now the legal representation will extend to the hearing and the actual questioning on sexual experience, which is better than nothing, but I think it goes only a very short way to giving the victim complainant any sense of empowerment or any sense of being in control in an area where so many offences happen, as a result of someone feeling that they were out of control, or they were being controlled, or their power was being diminished.
Nolene, you've 5 minutes.
Okay, great. Thanks, Maeve. I will, the legal professionals' familiarity needs to be built up as well, and there is work starting on that at the moment. I understand that there's a tender out oh yeah, in fact, I think the tender has been filled, and we should hear more about legal training at some stage, and counsellors to furnish notes properly. That, of course, does not refer to any of the rape crisis centres. We work that out, or 1 in 4, but just there is a variation between practices. So the question of information for victims, I spoke a little bit about it earlier, the website, extending greater access to court familiarisation and personal support, and 1 in 4, and the rape crisis centres all do that already. We are extending ours just at the moment significantly, and there is just to make sure that those who need it have the emotional support that they need when they go to court. There is also to be an extension to legal advice, and I think this has been really missing, where people can get legal advice from lawyers in the Legal Aid Board on what their rights are and what the limitations on their rights are. In terms of delay, again, Miriam has this covered, but the preliminary hearings, the rules of court are going to take time. And I would just point out that when in the last recession, when Judge Peter Kelly at the time was running the commercial courts, and big business was going up and down to court every day during the recession when they were all in trouble, it took no time at all to put rules of court in place so that there would be effective, efficient hearings. I think that's the level at which we need these hearings in place. It is just too bad that maybe this legal year, we still won't have preliminary trials up and running while court rules are being considered. There are huge delays at the moment. I'd say probably everyone on the call who has dealings with people going to court knows this, and we're getting, our people are getting dates in 2023 and the rest of it, remembering that in these cases, a person has to hold on to every single bit of the harm done to them until a court case is over. There's a judicial planning group was just launched on the 18th of October, too, just in terms of judges. And there's a public consultation until the 12th of November 2021 to examine the wider judicial resource needs of all the courts. Certainly, we're going to put something into that about the lack of judges, the lack of resources, and I think it might be useful if lots of us did that. In terms of training, the training is to happen. And I see both the Bar Council and the Law Society are doing some work in that area. I think it'll have to be standardised. The judiciary has also started training, and some of their early training was on dealing with vulnerable witnesses. So,
Nolene, you have 1 minute.
This is my last slide, Maeve, so my timing, thank you very much for that. I just put this in. This is a Department of Justice slide, which talks about the length to which the victim's journey is to be supported. And what I've spoken about are sort of the middle ones there, but to recognise as well that this also has to take into account what's going to happen post-trial and post-release. And so therefore there is an awful lot of work to be done. There are some good stepping stones in place, but there is a distance to go still. Thanks very much. I'm done, Maeve.
Thank you, Nolene. So what we will do now is open to some questions or comments from the participants. So if we can have the panelists back, Kerry. Excellent. Okay. One question which I think would be for both speakers. What do you see as the biggest challenge for the courts in dealing with sexual offences?
Ollie, do you want to go ahead on that one?
No, you go ahead there, I think.
Okay. Well, I think we both mentioned, delay, and I think as Nolene really well put it so well, that you're holding something that is very, just incredibly traumatic for a long space of time, and that there's so many issues regarding it, I think, that are, you know, in terms of the vulnerability of the control aspects, and all of those questions are just so complex in these cases. So I think delay then just is so awful and it exacerbates that sense of no agency, I think. But I think that from a practitioner's point of view, it's the uncertainty is whether something's going to get on or not. And also the aspect of, say, disclosure coming in, and that out of a clear blue sky, you might have everything going, perceived to be going okay. Everybody wants to get on. You've got the judge, you've got everything, and then suddenly you'll get a call or something will happen. And so I think the difficulty, I suppose, when you look at the list in the legal diary, so many cases have just are cases involving sexual offences. So to try and ring fence and try and get these to a point, it's a huge amount of cases that would have to have a very, very short time to get, say, within 6 months or within. But I love that you touched on that, Nolan, in terms of the commercial court. With all of the stuff that they had to deal with, they can still manage to organise their trial lists in a very, very short space of time, given a particular quantity value of that case. And we are putting cases that have an emotional quality that is much more valuable than that down the line, and procrastinating in terms of how we actually deal with them. I think that's changing, but I think that it means that unfortunately it has to come from above, and the Court of Appeal saying, no, if you don't get this on, we're throwing it out. We're doing it has to come from above. There has to be some sanctions that says this is getting on, whether it's this judge is taking this list and that's how he or she is running it. This is getting on no matter what. Or it means that there are, particularly you mentioned about trained barristers or solicitors in terms of the practitioners who are, this is how we have to deal with this. And there's a cultural change in getting things on. That to me, I suppose that uncertainty has to be one of the most corrosive elements, I think. But I really want to hear from Nolan about this. I think they are solvable problems, to be honest, because they've been solved in other courts.
Yeah, that's absolutely true, and it's kind of on the same. So a variation on a theme is all I'm going to suggest in answer to that. It's that sense of not being in control, of being just at the mercy of everything that is happening. You're going to give evidence about some of the most intimate things that you would rarely discuss with anyone, let alone with strangers. And you don't know when it's going to happen. You don't know how long it's going to take. You don't know when it's going to come up. There's so little, you have so little control over things. And again, just like my background as a solicitor, and I did a lot of family law and, you know, other areas, tough areas as well, like refugee law and that kind of thing. But they always knew they had someone minding their back in some ways. I think the accompaniment service that your organisation does and that we do and others is the nearest that the lucky ones get to having somebody really to mind them along the way. And it's not the same as being properly in control, because we are so careful that we can't be seen to be leading or coaching or influencing in any way whatsoever. But what we then can't do is prepare people properly as well as we could. So the defendant can't be led or coached either, but they can be taken through all their statements carefully and rigorously to check that they understand it all and that their lawyer understands it all. And that's missing. So the level at which you're out of control in a situation where your own control was violated in the offence, I think remains a huge problem.
Yeah, I understand completely in terms of the lack of representation, and I think that bizarrely, because it would mean more work for us, but that petitioners didn't want another, and I think are resistant to that aspect of separate legal representation, which is coming through, because it adds another level of potential for more difficulty. When I think that the whole system actually just, if Nolan, you probably know more, and maybe, but I have a limited knowledge of the inquisitorial system. But it does strike me that sometimes practitioners are really obliged to make decisions that they have to, because they are looking ahead to see, depending on how this goes, how will the Court of Appeal judge my action now if I don't object to this, if I do this now, so that if a defense practitioner who may not want to cross-examine the Court of Appeal recently had a judgment which said, well, we can't tell whether or not there was delay effect to the competency of the witness because you didn't cross-examine. That means that really the signal is you're going to have to cross-examine even if you don't really want to. If the prosecution they will need to say, well, no, we don't want. You can actually, this witness is a credible witness. Go ahead and cross-examine, because they again don't want to say, well, they don't want to put themselves in a position where they're painted into a corner by later on in the process. And so I often feel sometimes when you're looking at a trial, a lot of the positions that are taken are because they have to be taken because of the way the system is built. And if you've got people around a table, in a sense that they weren't looking over their shoulder to see how it might affect, there might be a better atmosphere in terms of the investigation and what is necessary for the investigation and the dealing with the offence. That's a bit Pollyanna, I know. But
but you see, I think in a sense it's part of the problem with the Victims of Crime Act, which comes from a European directive, which is much more used to that inquisitorial system. And we are having trouble, I think, in our system in adapting to that European approach to recognizing rights in victims. I mean, the fact that O'Malley called it a contest, it speaks exactly to what you were talking about there, Miriam. It has who's winning the contest along the way. That is not conducive to recognizing the rights of the victim. And you can't recognize them if they're not part of the process. And really, the reason O'Malley says is you can't have it is that we've never had it. And like somebody else put it to me, it'd be too messy. And those are the best reasons I've heard for not having a proper space for victims. But we are not. It seems to me we don't even know properly how to address the victims' rights because we are not used to that civil law approach.
Okay, I mean, one of the aspects of the criminal trial that our clients find most distressing and re-traumatizing is the cross-examination. Now, I'm aware that in some other jurisdictions, both the prosecution and defence have to submit to the trial judge the line of questioning they're going to take, and the trial judge has the right to say that, that's inappropriate or irrelevant or undermining of the victim. Our clients talk about, their entire credibility, their personality being put on trial rather than the actual evidence that's there. Would you have thoughts on that, Miriam?
Yes, I mean, I think maybe what you might be talking about is the system in England and Wales, where they brought in a full recorded cross-examination, and in the doing of that, they actually, the cases where they piloted, the judges said, you're going to submit your questions to us, and they also have extended use of intermediaries for particularly vulnerable witnesses. And a different, if you're talking about the meaning of vulnerable, they have a different understanding of vulnerable witnesses in terms of fear or intimidation. And so I think it's a lot more extensive. So the use of intermediaries has really changed things, I think. And then the submission of questions for cross-examination has then been, they kind of rolled back a little bit about it, saying, well, you can ask questions where there's an intermediary or where there is, you're putting them in better terms, I suppose. But you're absolutely right that the cross-examination had been somewhat curtailed by length and duration and content. That would be quite inconceivable here, only to the extent that submission ahead of time to say what I'm going to ask, I think you'd be going straight to an appeal on that, and straight to the Supreme Court, I would say, because of our constitutional right to cross-examination. However, looking at how there's two aspects of that. I think that we have seen intermediaries explaining to the courts why, if you ask a certain kind of question, why you might get unreliable evidence. And that speaks to, well, the courts want to have reliable evidence, and they don't want to be in a situation where it isn't acknowledged by everybody that if you ask it that way, particularly of a vulnerable witness, that you might get a witness who will acquiesce due to very many reasons, whether not understanding or feeling that the person in authority is asking them something. But absolutely, the language of the courts, I think, has to be modified for any witness to be respectful and to treat a witness with dignity. Unfortunately, the defence still have to challenge on instructions from their clients as to what the account has been, and therefore that has to be done, and we have to learn how to do that in a respectful and dignified way. But unfortunately, the case law is we need to be able to put the case to the witness. So I think there have been modifications in respect of cross-examination that I would really question as whether or not we're going to get that here, because of how it's come about in England and Wales, in terms of full recorded cross-examination. But I think with education and with a cultural change, a slow development, there will be a different way. The bullying, the making a witness cry, I'm sure you have different experiences. I know that is not something that I see often, and it's very, very rare because it's not in any way favorable to anybody to have that happen. But there can still be very complicated questions put to a witness who is possibly in a very vulnerable state, possibly emotionally flooding and not being able to answer the question. And I think it's up to the prosecution and the judge to say, we'll take a break. Can you make sure that witness is okay and understanding the question to be able to answer it. But if I could just touch on full recorded cross-examination, I was quite disappointed in terms of, say, an inquisitorial process within an adversarial process, that firstly, that the O'Malley report is not very much in favour of full recorded cross-examination. I think that might be due to disclosure issues, and the Bar Council also isn't in favour. And so that aspirational aspect of saying, well, can we take the recorded testimony out of can we take the complainant or the witness out of the trial process by at least letting them give their evidence ahead of the trial? It just doesn't seem to be on anybody's landscape, which I think is unfortunate. And even though it is in very limited circumstances at the moment, for children or persons with an intellectual disability, if that could have been extended, it might have been somewhere an option that might have been available for some witnesses. Sorry, I'm talking an awful lot there, but unfortunately,
and in fact, there's another question that's come in, which is really on that. Do you feel that judges intervene sufficiently during cross if a witness is, for example, being bullied or whatever? Do judges take enough charge of the court, if you like, and of the trial?
I think from what I've seen that they do, but I think I haven't seen. You see, I think the stereotypes of bullying barristers making witnesses cry. Nolene and Maeve, please come in on me on this, but that isn't the issue. I think the atmosphere itself, as Nolene talked, the binary contest, you're in, the pressures that are on you on the witness box to be able to swear up to the offences and to be able to then be able to answer any question on issues that are awful, really. It doesn't need somebody who's being bullying or aggressive to make it difficult to understand. The situation itself doesn't lend to that. So I think the issue is judges will intervene if there is any bullying, or if there isn't enough time to answer the question, or if there is any kind of aggressive manner, which is really obvious. So I haven't seen a judge have to intervene, perhaps to say, can we slow down, or perhaps do you want to take a break? But I don't think that that's the issue. I think that there's still enough in a very competent defence barrister to be able to put things in a way that is complex enough and I think that whole manner of inquiry in terms of cross-examination can be looked at for the judges to understand, actually, that question isn't being understood because of the way it's being put and in the way it's being, and even though that person are they really understanding the question that's being put? That's more for vulnerable witnesses. I think that people can can certainly surprise you in the witness box as to how strong they are. And I don't think judges want to interfere with that as well. I think that they want to allow people to have their voice. And the unfortunate thing is that it's not a one size fits all. And I think that's the problem. I think that's where training for the judiciary to know when to intervene or not intervene. And I know that judicial training has involved unconscious bias, and an awful lot of those aspects I think judges are beginning to question themselves.
Okay.
Very long-winded answer. I'm sorry.
Unfortunately, we've just run out of time. I think we could spend the afternoon actually teasing out all the various aspects of this. So I'd really like to thank our two speakers, Miriam and Nolene, so much for taking part today. It's such a complex issue, and I mean, O'Malley is only just over a year old. So I think Victims' Rights Alliance will probably revisit this in maybe another 18 months or so to see where the various pieces that you both mentioned have been implemented and the difference that maybe it's making. The next VRA webinar will be on the 25th of November at 1 p.m. and it's discussing the need or the possibility of introducing a victims commissioner or a victims ombudsman into this country. And we have two international speakers, so we let you know who they are, one who has experience being a victims commissioner and the other looking from the European perspective. So I hope we will see you all again. So just to thank everybody for attending today, and again, a big thank you to our two speakers.
Thanks very much, Maeve. Thanks all.
Thank you. Glad to be here.